Welcome, everyone. It's delightful to see you. Thank you so much for being here with us this afternoon. I want to thank everyone who's made this event possible. Thank you to Debbie Hellman for serving as the faculty organizer for this book panel. And thanks to everyone else at the law school who's had a hand in it. Many people work on events like these to make them happen, from communications to law IT to building services, and especially our events team, Rebecca and Laurel. Thanks to all of you for your work, and thanks to your work, we all get to enjoy this, so we're all very grateful. I also want to thank our panelists, Rebecca Wexler, Diego Zambrano, and James Fander, class of '82, for joining us from near and far. Welcome, or welcome back, as the case may be. And it's great to see all of you. Welcome to you as well. I'm so glad to be here to celebrate Dignity and Judicial Authority, written by our own Rachel Bajewski. Writing a book can be a long, intense, and solitary enterprise, but at the end of that sustained labor is an opportunity to share your work with the world, and we're thrilled to be able to come together today to celebrate Rachel's new book. Rachel Bajewski is an associate professor of law here at the law school, where she teaches and writes about constitutional law, federal courts, civil procedure, and legal theory. She received both her BA and her JD from Yale, and while at Yale Law School, she served as editor-in-chief of the Yale Law Journal. Rachel also has a master's in political theory and a DPhil in politics from Oxford, where she studied on a Rhodes Scholarship. Before joining our faculty, Rachel clerked for Judge Jed Rakoff of the U.S. District for the Southern District of New York, Chief Judge Robert Katzman of the U.S. Court of Appeals for the Second Circuit, and Justice Ruth Bader Ginsburg of the Supreme Court. She was also a Clemenko Fellow at Harvard Law School and a litigation attorney with Aiken Gump's Washington, D.C. office. We were thrilled to have Rachel join our faculty 3.5 years ago, and I'm equally thrilled to celebrate her first book and her flourishing legal and academic career together with you today. Let me speak just a bit about the book, but you're going to hear from better experts in just a moment. Rachel's book is entitled Dignity and Judicial Authority. It was recently published by Oxford University Press. In the book, Rachel tackles an oft-invoked and underexplored concept, human dignity, specifically human dignity as the basis for a legal claim, whether in the area of torts to human rights claims. Rachel offers an original theory of dignity, one that emphasizes respect for status, non-domination, and control over self-presentation to others. Her book also addresses how courts can recognize the loss of dignity as a legally actionable harm and provide remedies for this harm. This is a work of true significance, one which contributes to core legal and philosophical debates, and I'm delighted that we get to explore it with this panel of experts today. So I will first turn it over to Rachel, who is going to tell us a bit about the book before the panel proceeds. Welcome, Rachel.
Thank you, and thank you very much to the law school, especially Leslie and Mike Gilbert and Rebecca Claff for organizing this event, and to Debbie Hellman for moderating, and to the panelists for coming from far away. I know that it can be hard to travel, especially in the middle of the semester, and I'm very grateful to have you all here. And I'm also very grateful that you all have come, especially my students. So this book has its roots in a puzzle that I started thinking about when I was a graduate student in political theory, actually, that many people seem to view dignity as important, but they disagree on what dignity is, why it matters, and what ought to be done as a consequence. On dignity's importance, in the interpersonal realm, perceptions of respect and status and shame have a substantial impact on human behavior. In social life, societal arrangements and structures are often criticized or praised based on their propensity to advance or detract from human dignity. In particular, dignity is a foundational concept in the international human rights regime. At the same time, dignity is frequently criticized as hard to define, malleable, and subject to ideological manipulation. Both pro-lifers and pro-choicers claim the mantle of dignity, as do individuals on multiple sides of debates over affirmative action. So what does dignity actually have to offer us? The challenges of dignity are magnified when we enter the sphere of law, and specifically the law as it's interpreted and applied by judges, which is the focus of this book. So judges are required to define concepts, to draw lines, and to maintain the public's confidence that the courts are a site for impartial justice. These features of judging might seem in tension with dignity's apparent mushiness and its alleged ability to act as a vehicle for the ideological presuppositions of the person wielding it. So there's a temptation to say that judges ought to stay out of the dignity business. And my key aim in this book is to combat that perspective, to show that dignity can and should be usefully integrated into judicial decision-making. To do this, I start with the conceptual task of teasing out different understandings of dignity and offering my own, and then I discuss various legal settings in which dignity can play a role: constitutional standing doctrine, dignitary torts, the law of remedies, and court-mandated apologies. To begin with the conceptual part, dignity has multifaceted historical roots, from the Roman idea of dignitas to religious ideas about human beings being made in God's image, to Kantian ideas about treating people as ends and not mere means. So I break down these understandings of dignity along various axes and highlight where the fault lines lie. And then I offer my own view of dignity. I call it relational dignity. Relational because the meaning of dignity becomes clearer when we think about specific social relationships. And we can often get a handle on what dignity means by thinking about what happens to those relationships when dignity is violated. Relational dignity, as I understand it, has three elements: respect for people's status, non-domination in the sense of not being subject to the arbitrary will of others, and the ability to exercise control over one's self-presentation. And we can think of examples of violations of dignity that violate these elements. So on status, discrimination, many forms of it consigns certain people to a lower status and therefore fails to respect their proper status. Slavery subjects individuals to the arbitrary will of others, exposing people without their permission, so posting pictures, compromising pictures of an ex-partner on the internet, strips those targets of their ability to exercise control over self-presentation. So these are all core types of dignitary violations. Just a little note that although the dignitary violations I just named are quite serious, dignitary violations do run the gamut in terms of their gravity. So they can involve, speaking disrespectfully to a teacher, which is always very wrong, especially when it's directed against UVA law professors, to the worst forms of slavery and apartheid. Relatedly, my account doesn't treat violations of dignity as absolute wrongs. So a dignitary violation, as I understand it, is wrong, but it's not necessarily wrong, all things considered. In other words, the protection of dignity can be balanced against other goals. And I think this is significant if we want to try to integrate dignity into real-world legal regimes where courts need to make trade-offs among multiple values. So that's on the conceptual side, on the defining the concept of relational dignity. And with that concept in hand, I then address several legal settings in which dignity, so I argue, ought to play a role. So these settings are constitutional standing doctrine, dignitary torts, the law of remedies, and court-mandated apologies. And in discussing these topics, I focus on litigation in U.S. courts. And partly this is just, in the interest to narrow and cabin the inquiry, and also because dignity in U.S. courts presents a distinctive set of issues. So in the international human rights regime and in various comparative law settings, it's more common to refer to dignity, including as a constitutional value, whereas in the U.S., there tends to be a fair amount of dignity skepticism. So judges face particular challenges in integrating dignity into U.S. legal contexts. And in analyzing these particular legal settings, I emphasize this theme of judicial authority. So how judges handle dignity tells us about the power that they wield and are authorized to wield. If the promotion of dignity is not a proper judicial function, but instead it belongs to the sphere of families, community, social work, or even of legislatures, then judges are reaching beyond their allotted spheres in advancing dignitary goals. But if dignity is a concept that is cognizable in court, then judicial authority itself will extend more broadly. So dignity can help illuminate the question of what courts are for and what they can legitimately achieve. So I'll now go through the 4 legal settings where I examine the workings of dignity. So the first is constitutional standing doctrine. As many of you are likely familiar with, the case or controversy requirement in Article 3 of the U.S. Constitution has been interpreted to impose an injury in fact requirement on federal courts, meaning that plaintiffs have to be injured in fact in order to have standing to sue in federal court. And when plaintiffs are harmed in an economic or a physical way, it seems pretty straightforward to say, okay, they've been injured. But what about when plaintiffs experience dignitary harm, say because their privacy is violated or they're discriminated against, even if they don't incur economic injury? I argue that dignitary harm should not be excluded from the ambit of injury in fact, but there remains this question of how judges are to distinguish between cognizable and non-cognizable dignitary harm, especially because dignitary harm has the potential to significantly expand standing. And I suggest that judges develop, or really continue developing, a kind of common law of standing based on dignitary harm. They can look to constitutional and legislative provisions for guidance on whether dignitary harm is cognizable. They can consider whether particular types of plaintiffs are within the circle of those most likely to incur dignitary harm. So for instance, a plaintiff who walks by a government-sponsored religious message every day for 10 years should be more likely to assert injury than a plaintiff who hears about it once on the news. And in this way, judges can seek to structure the inquiry into the cognizability of dignitary harm. So the second substantive area that I discuss is dignitary torts. And I think tort concepts are important not only in terms of the litigation of actual tort cases, but also because ideas about harm and causation derived from tort law influence our thinking about law more generally, including various categories in public law. And sometimes judges and scholars refer to a category of dignitary torts, which seems to include torts whose primary effect is not to cause physical or economic harm, but rather to cause some other kind of harm. In the scholarly literature, including important contributions by our own Ken Abraham and Ted White, there's debate over whether a unified category of dignitary torts can be devised. So I don't try to delineate a clear category of dignitary torts, but I highlight certain causes of action in which the violation of dignity is a prominent aspect of the legal wrong. So for example, offensive touching battery, that is touch that's offensive but doesn't cause physical harm, invasion of privacy, defamation. So these are examples of causes of action where the violation of dignity is especially prominent. And these types of tort claims pose problems for courts related to how you find evidence of these types of harm and the challenge of distinguishing between actionable and non-actionable dignitary claims and fears about the floodgates of litigation. There are, however, ways for judges to address these issues, including the use of community standards, like talking about a reasonable sense of personal dignity and the participation of juries. So that's on the tort side. And then constitutional standing and tort law are both raising this question of how courts should address dignitary harm. And the next part of the book turns to the flip side, which is the question of remedy. To what extent should courts offer remedies for dignitary harm, and how should they do so? So I argue that remedying dignitary harm is an important part of restoring, as far as possible, plaintiffs' rightful position, and is also consonant with many parties' empirical goals in litigation. I highlight several ways in which courts can offer relief for dignitary harm, ranging from compensatory damages to punitive damages to nominal damages to declaratory judgments and even dicta in judicial opinions, which I argue could be considered at some level as a form of relief. Issuing a remedy that has the primary effect of expressing respect for the plaintiff whose rights were violated is, I contend, a legitimate judicial activity. And the question may arise about whether, do all legal violations warrant dignitary relief? So there's this concern that dignitary relief could not truly be cabined. And I suggest criteria that judges can use to determine whether dignitary relief is warranted. So they include the content of the legal violation. Does it involve a core violation of relational dignity, such as disrespect for status, domination, improper exposure? The defendant's intention, so if there's more malice on the defendant's part, that might be more likely to give rise to a dignitary claim. And the identity of the parties. So for instance, lawsuits that are brought by individuals rather than corporations or state entities might have a particular propensity to involve dignitary harm. In other words, there are ways to distinguish between contexts in which dignitary remedies are more and less suitable. And in the last chapter, I consider a particular type of remedy that I think has both dignitary benefits and dignitary drawbacks, and that's the idea of a court-ordered apology. So court-mandated apologies are not common in the US. They sound kind of weird, I suppose. They are employed in some criminal law settings. But there are quite common adjacent practices. So for example, judges giving lower sentences to defendants who express remorse or higher sentences to defendants that they don't perceive to be expressing remorse. And court-ordered apologies, they do have a dignitary benefit in the sense that they can help to vindicate the dignity of the plaintiff. So here I confront the objection that if it's a court-mandated apology, then it's a forced apology, and a forced apology can't be sincere, and an insincere apology does nothing for a plaintiff. And I argue against that view. I think an apology is a social act in addition to a window into the apologizer's soul, and the social impact of an apology can be to rehabilitate the plaintiff's status independent of the contents of the defendant's heart. So those are some dignitary benefits of court-mandated apologies. But at the same time, court-mandated apologies do have dignitary costs, so they can expose the defendant to ridicule in a manner that causes gratuitous humiliation. They can also raise First Amendment compelled speech problems because they seem to be forcing defendants to utter, as the Supreme Court says, what is not in their mind about a matter of significance. On the First Amendment issues, I suggest that it's not actually so simple to explain which First Amendment interest is contravened by court-mandated apologies, but concerns about the free expression and the dignitary impact of court-mandated apologies could militate in favor of requiring apologies from certain types of defendants rather than others. So for example, government defendants as opposed to individuals. Overall, I don't just say, thumbs up or thumbs down to court-mandated apologies, but I provide reasons to think that they're at least worth considering. And most importantly, the topic of court-mandated apologies shines a light on parts of our legal system that we might not be inclined to question. For example, the practice of judges considering defendants' expressions of remorse during sentencing. The overall aim of discussing these particular legal contexts is to demonstrate that dignity has a genuine role to play in American courts, that it's not just this pie-in-the-sky philosophical concept, but that it's an important quality of real-world social relations that has an appropriate place in judicial decision-making. I don't think at all that the task of integrating dignity into judicial decision-making is simple, and there's surely much more to be worked out, but I don't think that judges or commentators should throw up their hands and say that dignity is just too slippery to deal with. Instead, we should focus on ways to regularize dignitary inquiries and allocate institutional authority to make these decisions in a productive fashion. That, to my mind, is the best way to realize dignity's promise. I look forward to all of your questions and comments.
Thank you so much, Rachel. That was fabulous. I'm so glad we had a summary of the book so those of you who haven't read it yet know what it's about and can understand and participate in the conversation as we get the commentators' takes on that book. And as you saw, the books are for sale outside in case you want to buy one afterward. So I have the pleasure, I'm Debbie Hellman, professor of law here, and I have the pleasure of introducing our distinguished panelists. And I'm going to introduce them in the order in which they're going to speak. So the first is James Pfander. He's the Owen L. Kuhn Professor of Law at the Pritzker School of Law at Northwestern University. Pfander's recent scholarship focuses on the role of courts in securing government accountability. His latest book, Cases Without Controversies, Uncontested Adjudication in Article III Courts, published by Oxford University Press in 2021, explores the history of litigation in the courts of the United States, showing that Congress had the power to assign the federal courts cognizance of no injury claims to register a claim of right under federal law. The book builds on that history to propose a new account of the meaning of cases and controversies from Article 3. He's also written numerous articles and other books on related topics, including Constitutional Torts and the War on Terror, also from Oxford Press 2017, and case books on civil procedure and federal courts. Next, we'll hear from Professor Rebecca Wexler. She's the Hostel Armstrong Professor of Law at UC Berkeley Law School. In addition, she's faculty co-director of the Berkeley Center for Law and Technology. Wexler's teaching and research focus is on data, technology, and secrecy in the criminal legal system. In particular, she's also written extensively on privacy, which is an important site in which the legal role of dignity is often discussed. She served as a senior policy advisor in the White House Office of Science and Technology Policy in the spring of 2023, and was a visiting professor of law at Columbia Law School in the fall of 2023, and also is currently visiting at Chicago, which I just learned. No.
Just on sabbatical.
Just on sabbatical. Sorry, misunderstood that. Okay, because that wasn't anywhere written. I should never have ad-libbed. Okay, Professor Diego Zambrano, who's our third panelist today, is Professor of Law, Associate Dean for Global Programs, and Faculty Director of the Newcomb Center for the Rule of Law at Stanford Law School. Zambrano's primary research and teaching interests lie in the areas of civil procedure, transnational litigation, and judicial federalism. His work explores the civil litigation landscape, the institutions, norms, and incentives that influence litigant and judicial behavior. He also has an interest in comparative constitutional law and legal developments related to Latin America. His work has been honored by the American Association of Law Schools and the National Civil Justice Institute. He's a co-author of a leading case book in civil procedure, Marcus, Vander, and Reddish, with our first panelist. As you can see, we have a distinguished group of panelists, and we'll hear from them, and then I'll moderate a discussion among them and including the audience. Thanks so much. Jim.
Well, it's great to be back here to talk about Rachel's book, the more so because this is my first legal home, as my placard indicates. So thanks to Rachel for this great book, and thanks to my co-panelists. I'm rarely the first person up when the panel speaks alphabetically, so hats off to Wexler and Zambrano for making that happen for me today. So book conferences can pose timing challenges. If they come too early, then they encounter an author with developing ideas. And if they come too late, they encounter an author perhaps who has moved on to the next project. So I'm trying to finesse this timing problem with two different lines of commentary. The first line focuses on some of the specific claims in the book, testing, prodding, interrogating. This line of commentary has only confirmed me in my admiration for the care with which Rachel works. Time and again, questions occurred to me as I read along and were promptly addressed and dispelled in subsequent paragraphs. The second line of commentary steps back from the book a bit and asks a different question. Why didn't you write a different book? No, not really. I'm not going to ask that question, but I am going to reflect a bit on what it means that Rachel chose to situate her work in part in the law of constitutional standing rather than more completely in the law of dignitary harm and tort. So that's the concluding reflection. So before the particulars, there's no reason, I think, to offer any further overview of the book. That's been nicely handled by the author herself. But among the things that I find really appealing about the book is the demonstration of an engagement with the idea of a dignity across continents and across time. Rachel shows us that the idea of dignity became more salient after World War II and in the rise of human rights consciousness. But also shows us that dignity has roots that go much further back into the history of tort-based redress. This origin story I find quite powerful and very well written. And then interrogating the role of dignity in modern adjudication, she starts with Article 3 standing, as we know, and then takes up the dignitary torts and remedies. And in the world of remedies, quite a nice command of the doctrine, as I think is true throughout. Rachel works to show that courts can manage an encounter with dignitary interests without losing their balance and skiing all the way down that proverbial slippery slope. So she's trying to give us a look at dignity not from just a single perspective, but from across multiple points of judicial encounter. As I said, I have great admiration for the work. Rachel writes with a clarity we should all envy, displaying equal facility with the philosophical and the legal underpinnings of dignity, and does so with a brevity I admire and, frankly, often fail to achieve in my own work. She tackles the problem in a cross-cutting evaluation that demonstrates command of a wide range of doctrinal nuances and succeeds, I think, in the end, placing dignity more clearly within the framework of interests that courts can and do manage in the course of everyday adjudication. So, some particulars. I was initially struck by Rachel's careful engagement with standing doctrine, which she ably reconstructs and uses as the basis for evaluating the role of courts in adjudicating dignitary harm. Rachel rightly acknowledges, I think, that courts may fear that the acceptance of dignitary harm as an injury in fact will lead to unbridled ideological litigation as litigants invoke intangible harm as the vehicle for challenging practices that they find in some sense offensive. Rachel would ward off that concern by calling for proof of the way an individual reacted to offensive stimuli. As she explains, the fact that dignitary harm takes place on a plane of psyche doesn't render it impervious to proof. But that led me to wonder what kind of proof we will see. I was thinking about the case of Carey versus Pifus, which upholds a nominal damage award for breach of procedural due process, in part to allow vindication of dignitary interests. But Carey also forecloses presumed damages and calls for evidentiary proof of compensatory damages. So what should we expect to happen? In a word, woodshedding. Lawyers will coach their clients. Lawyers know that their clients must testify to some acute harm suffered as a result of a due process violation under Carey in order to recover compensatory damages. And so we get contrived testimony. Consider the evidence that was offered in support of one Carey claim as quoted by the Fifth Circuit. Here we go. The discharged doctor and his wife both testified specifically that the summary proceedings surrounding his dismissal caused severe anxiety and distress, and that these feelings were not relieved until after the full hearing was held on his discharge. So that compensable injuries don't flow from the discharge, but from the severe stress that was occasioned by the absence of full procedural due process. That's the testimony taken at face value by the Fifth Circuit, and the creature really at the end of the day of a doctrinal turn that requires that kind of evidence as a way to demonstrate that you have an actionable claim for compensatory damages. One might worry that similar forms of more or less contrived dignitary harm might crop up in depositions offered to defend a plaintiff's right to litigate other constitutional claims. So, a question, would we do better if we compensated dignitary harms not as a thing in itself, but as an additional remedy for an established tort or other form of injury? Apart from the problem of the contrived claim, one might come to wonder that a litigation system that recognizes assertions of dignitary harm will tend to encourage individuals to cling to a sense of victimization rather than to take pride in resilience. I don't want to press this idea very hard. It makes me sound like a boomer. And I recall the Supreme Court in Plessy versus Ferguson downplaying the plaintiff's claim of dignitary injury occasioned by Jim Crow segregation as only an interpretation that the plaintiffs chose to place on the law. So another question, how can we prevent the courts from refusing to take dignitary harm seriously? One solution Rachel develops in the book might help reliance on community standards. There's little doubt that such standards can help moderate the role of contrived claims of dignitary harm. Both the judge and the jury will consult their own lived experience as they evaluate the claim of injury, distinguishing perhaps between stubbed psychic toes and more severe forms of harm. But community standards may not always help. It seems doubtful that New Orleans as a community had come to recognize the dignitary problems with segregation at the time of Plessy. And by the same token, such standards may not recognize some of the most pressing forms of dignitary harm today. Consider the affront to self-presentation posed by governmental suppression of gender non-conforming choices. Dignity would seem to lie at the heart of this claim of harm, and yet the community may not broadly recognize the harm as actionable or worthy of redress. On the whole, I found myself quite in agreement with Rachel's assessment of many indignities, such as the public sharing of private nude photos. But it seems to me that some of the hypotheticals in the book involve claims that Rachel rightly describes as small c conservative values. We can all agree that Marcus, the stranger in a restatement scenario in the book who fondles a sleeping subway passenger, has violated that person's dignity. I think we can also agree that the so-called friend who tells that person later about what happened and didn't intervene at the time isn't much of a friend. But that takes us away from the dignitary inquiry, I suppose. Anyway, we can also agree, I think, that the community won't always come to the defense of trans people. Rachel does a very sophisticated job of engaging with the First Amendment, which, as she notes, has been described as threatening to swallow the dignitary torts. She ultimately protects or accepts the value of political speech and concludes that certain forms of dignitary harm may be visited on public figures in much the way defamation law now allows. And that strikes me as a sensible accommodation, but I found myself wanting to hear more about the European norms of privacy and self-presentation, norms that don't always give way when the individual steps into public office. The chapter on remedies for dignitary harm strikes me as very impressive in its command of remedial law. Rachel demonstrates a fine understanding of the roles of compensation, vindication, punishment, and the importance of restoring the claimant's rightful position. And in a bold and well-argued extension suggests that judicial dictum might be used as an additional remedial tool for dignitary harm. I found the argument interesting and novel and provocative, but entertained some doubts as to the remedial efficacy of such judicial writing, which might be understood to operate as a kind of consolation prize. I understand that some might take solace in the court's recognition of their plight, but it calls to mind what my friends the economists call cheap talk. And so one wonders about the vindicative power of such language in a judicial opinion. At the same time, Rachel also shows us that dignity can address some nettlesome problems in the doctrine. And I very much liked her use of dignity to try to resolve the doctrinal discontinuities that were created by the recognition of nominal damages in one of my favorite tort cases, the Usick-Boonham case on standing and mootness. Now, stepping back from these particulars, I wanted to reflect for a moment about what Rachel's book teaches us about the nature of law at this moment in the 21st century. Or to put the question more pointedly, what can we learn from Rachel's decision to focus the book in part on dignitary litigation under Article 3 of the Federal Constitution? One might read this splendid book as providing a nice foundation for the recognition of a brand new tort. Consider, for example, the fact that the tort of intentional infliction of emotional distress, or IEED, took hold after Professor Prosser published his article on the subject in 1939. Now, if Rachel were to have prosed a new tort, she would doubtlessly have chosen a much snappier name. IED is way too clunky. So is intentional infliction of dignitary harm, IIDH, but maybe dignitary affront or dignitary assault would work, a formulation that likens dignitary harm to the injuries inflicted by an assault. Of course, I'm not faulting Rachel's choice. We have plenty of dignitary torts and a new focus on dignitary remedies in the second or the third restatement, and that's perhaps tort development enough for now. But there is something to learn, I think, from our current predicament as reflected in Rachel's entirely understandable decision to pitch her intervention to some extent in constitutional terms. The court has chosen, somewhat controversially in my view, to reframe its assessment of injury and causation and redress, all topics that tort law has managed quite nicely over the centuries, in terms of Article 3's case or controversy language. In one sense, we can understand the court's move. Supreme Courts have long played a role in defining actionable claims in the shadow of legislation that confers new rights. And our Supreme Court lost much of its control over the contours of tort with the announcement of the Erie Doctrine. Standing law framed in constitutional terms has arisen in the shadow of Erie as a way for the court to claw back some control over the definition of rights to sue that it ceded in 1938. But the reclaimed authority imposes serious costs, as Rachel's work so clearly reveals. Consider a thought experiment. Can we imagine a federal court in the 1950s refusing to adjudicate an IIED claim on the basis that the injury to the person's mental health wasn't quite sufficient to justify federal adjudication, even though it was actionable under state law? Nope. Can we imagine a federal court today invalidating a statute adopted by Congress that recognized new injuries and rights to sue to address privacy and, yes, dignitary concerns in the information age? Yes, we can, actually. We saw it happen in 2021 in the TransUnion case. We see other examples of what one might call the constitutionalization of tort law, its incorporation by fits and starts into the constitutional torts regime that has developed under Section 1983. We see it again in the now you see me, now you don't appearance of law governing tortious misconduct by federal government officials, also known as the Bivens Doctrine. For better or worse, the court has fashioned a distinctive body of federal tort law, sometimes called standing, sometimes framed as constitutional tort, that it can manage and administer free from any thought to the decisions of other courts and lawmakers. This relentless turn to the Constitution may raise the stakes unduly. The court may be more reluctant to award damages for constitutional than for garden variety torts. One lasting and unfortunate consequence of the federalization of tort law has been that the court's work in this area has separated U.S. law from that of other common law countries. So instead of interrogating tort developments in the UK or Canada or Australia, the court considers only its own muse as it refines the law of standing and federal tort liability. One might argue that by moving away from a shared discourse of tort liability, the court has championed a form of American legal exceptionalism. Even the court's own precedents from the 19th century often go missing in modern cases, as we saw so clearly in Hernandez versus Mesa, the cross-border shooting case from 2020. Don't blame Rachel, she gets all this. In interrogating the meaning of dignity, she closely attends to international and comparative signals from around the world. Her work seeks to reclaim a kind of common law discourse about the role of dignity. We can't ask Rachel to fix all that has gone wrong with the constitutionalization of tort law, but we can say thanks, most sincerely, for all the progress she has made.
So first of all, I want to say thank you so much for having me here. I've been an admirer from afar of Rachel's work for a long time, and remember talking with her right after we graduated from law school about some of her ideas on dignity and the courts. So it is such a pleasure to see her with this wonderful book. Congratulations, Rachel. What I want to talk about today is a fascinating flip at the end of Rachel's book. For the vast majority of the book, Rachel paints a picture that I think can be fairly and unsurprisingly characterized as pro-dignity and pro-judicial authority. And then, in a brief 10 pages at the end, she flips it. So I'm not sure Rachel would agree with this characterization, so I'll explain. I'll first describe what I think are the sunny portions of the book, raising a few questions about them along the way, and then I'll talk about the flip. So the sunny parts. Reading this book convinced me that Rachel thinks dignity is a good thing. Her opening intellectual history tour of dignity expertly disbands concerns that the concept is too wispy or too malleable to be a useful subject for judicial rulings. For instance, even if dignity can be invoked on opposing sides of the same debate, as in abortion, affirmative action, conflicts between anti-discrimination law, religious liberty, and free speech, Rachel assures us that dignity doesn't cancel itself out, but rather can help focus debates and make them more manageable. And while Rachel acknowledges that protecting dignity will come with trade-offs, maybe trade-offs with liberty or trade-offs with security, she points out that balancing competing interests is familiar territory for courts. I found her approach persuasive. After all, lots of rights talk can be invoked on opposing sides of a debate. It's lawyers' bread and butter to turn an adversary's position against them, and that doesn't mean it should be beyond the power of courts to adjudicate those issues. While dignity might be a shapeshifter, its absence in society would be devastating. If I could sum up part one then, it would be, don't give up on dignity. Yes, it's got some challenges, but so do we all, and that doesn't mean we don't belong here. Rachel also thinks that giving courts authority to address and remedy dignitary harms is a good thing. Part two and most of part three are devoted to persuading readers of exactly this, and they accomplish the goal beautifully. Sure, there are problems. Dignity might seem too intangible, present evidentiary challenges, create a line drawing fiasco. But courts overcome these issues elsewhere, and they can do it here too. As it turns out, courts toggle their description of tangibility depending on their normative commitments. Lots of stuff is hard to prove. Think of mens rea as an example. That doesn't mean we keep it out of court. And the way to solve line drawing problems is, as Professor Fander also referenced a quote from Rachel's book, by not skiing all the way down the slippery slope. In short, more courts, please. None of this is surprising. It's the thesis of Rachel's book, and she defends it exceptionally well. The book presents a sunny portrait of dignity and of courts. Before I move on to what I'm claiming is the flip, I'll take a minute to share some questions that the book left answered to me in no particular order, and not to suggest in any way that the book needed to address them, but because perchance they might interest Rachel as a direction for future work. So to start, and this question may just expose my total ignorance about standing doctrine, but could we avoid some of the standing conundrums that Rachel is concerned with by having the government prosecute dignitary violations as crimes? At least some crimes don't seem to fit into the concrete particularized injury in fact paradigm, like the crime of possessing obscenity with the intent to sell or distribute it. If the idea here is that society is the one injured by such violations, and that injury to society is sufficient for Article 3, could that logic extend to other dignitary harms not yet criminalized? Next, at one point in the book, Rachel critiques some other scholars' account, Sugarman and Butcher, as risking significantly expanding the category of dignitary violations. And it made me think I wasn't quite sure whether Rachel also wanted to expand the category of dignitary violations, or was primarily trying to justify violations that were currently cognizable. So maybe in future work she would talk about where they might expand. Does it matter if courts call what they are doing dignity? Maybe it wouldn't make a difference if they gave the same remedies in the same factual circumstances under a different name. Or maybe identifying it as dignity, which Rachel does, groups different areas of doctrine together in a new way that can change how we think about them. And what else could society do to redress dignitary harm other than through the courts or through the law? Okay, so now let me talk about the flip. I would like to propose that in the last 10 pages of the book, or 10 pages toward the very end of the book, titled Court-Mandated Apologies and the Violation of Dignity, that those last 10 pages turn Rachel's sunny portrait of dignity and of courts somewhat on its head. That they open a little crack in the facade by pointing out that some judicial remedies for dignitary harms, as Rachel readily accepted and delves into, such as court-mandated apologies, might themselves impose dignitary harms. As a bit of an aside, I'm not sure court-mandated apologies are actually as infrequent as we might think. I've seen one in criminal proceeding in New York State before a packed courtroom filled mainly with unrelated people and lawyers waiting for their own cases to be called. And all the questions that Rachel raises about coercion and sincerity, gratuitous humiliation versus rehabilitation, compelled speech and thought, courts, quote, making someone sing, were right at the surface in that courtroom, in that hearing. So perhaps that's why I found this section of Rachel's book so striking. In any event, reading her account of court-mandated apologies made me wonder whether using courts more generally to address dignitary harms could make things all around worse for dignity. Maybe there is a dark side of dignity and judicial authority. So admittedly, I might be overreaching. As is typical of the book as a whole, Rachel meticulously anticipates, acknowledges, and rebuts categorical objections to court-mandated apologies. Yes, she tells us they risk violating dignity through gratuitous humiliation, by violating individual defendants' control over their self-presentation to others, by compelling them to speak what's not in their minds, or by using them as a means to further societal aims. But, as Rachel points out, that's all true of lots of criminal punishment, from imprisonment to orders to pay damages. All of it uses individual defendants as a means to societal ends. And even if what you're worried about is a tyrannical Orwellian regime that uses shame sanctions like public confession, think again, Rachel tells us, because court-ordered apologies do not stand alone in their capacity to stigmatize. Quote, many people are willing to live with other heavy-handed judicial sanctions. So Rachel says, why pick on apology? Yet, as she herself acknowledges, this argument can lead in two directions. First, accept judicially compelled apologies as a valuable remedy, albeit with careful consideration of countervailing indications in individual cases. Or second, stop picking on apology and start picking more generally on all sorts of dignitary violations that courts perpetrate. So looking ahead to what Rachel might do next, I want to invite her to take direction number 2 seriously. I worry that there may be lots more to say about this darker side of dignity and of courts, enough for Rachel to write the cynical sequel to this book. Perhaps part 1 of this cynical sequel could focus on courts' pretextual uses of dignity. So let me explain what I mean. At various points in the book, Rachel briefly mentions evidentiary concerns about proving dignitary harm, something Professor Fander also brought up. One area, somewhat adjacent related, in which evidence law explicitly addresses dignity is privilege law. Privileges for communications between spouses, clergy and penitents, even attorneys and clients, are sometimes justified on the basis that they protect the dignity of these special relationships from excessive intrusion by the judiciary. But another explanation is that were courts to attempt to compel disclosures of confidences made in those special relationships, people would just refuse to comply. They would not show up in court, they would refuse to answer questions on the stand, or they would lie. So what courts are actually doing when they recognize evidentiary privileges is trying to avoid visible affronts to their authority while concealing this admission of weakness by labeling it a dignitary protection. Maybe there are other examples of courts using pretextual dignity claims as a smokescreen for some other motivation. Perhaps Rachel could identify these and devise some way of distinguishing the genuine from the pretextual. Perhaps part 2 of the cynical sequel could focus on dignitary biases. Why is it, I wondered while reading Rachel's book, that the core examples of court-mandated apologies and practices adjacent to them are exercised against criminal defendants and not civil defendants, with the exception of government defendants in civil rights suits? Isn't there a repair and rehabilitation justification for court-mandated apologies in civil cases? Why do courts claim they lack equitable authority to mandate apologies in civil cases, but decide it's within their authority to do so in criminal cases? Courts impose higher sentences on criminal defendants who fail to show remorse. Do they also approve higher jury awards against civil defendants who fail to show remorse? If not, does dignity just become yet another arsenal for courts to discriminate? Or in terms of Rachel's own account of relational dignity, to engage in status violations or arbitrary domination? And finally, for part 3 of the cynical sequel, I want to invite Rachel to take up her own proposition on page 167 that if one is concerned about dignitary harms from court-mandated apologies, quote, one might also oppose other types of judicial rulings, including imprisonment. This is the idea of courts as perpetrators of dignitary harm. Surely this happens more frequently than just through court-mandated apologies. I'm thinking of Judge Julius Hoffman ordering that Bobby Seale be bound and gagged in the courtroom. I'm thinking of a Texas court permitting prosecutors to introduce Cameron Todd Willingham's apparent lack of remorse at the death of his 3 children as evidence that he murdered them, a charge to which he refused to plead guilty and for which he was later executed despite many people believing and much evidence to show that he was factually innocent. Or how about the death penalty more generally, whether in its current arbitrary and racially biased application or in its idealized neutral incarnation? More abstract, maybe a little bit leavening of the conversation. If, as Rachel tells us at the beginning of the book, dignity is on both sides of contentious debates, how can courts ever avoid perpetrating dignitary harms when they rule for one side versus the other? Maybe giving courts more authority is not always good from a dignitary perspective. So those are some of my imaginations about a possible new line of scholarship building on this wonderful book as its foundation, but exploring the underbelly of the issues Rachel has already brought to the fore. Dignity and Judicial Authority 2.0 with a newly pessimistic spin. In conclusion, let me say how tremendously much I enjoyed reading Rachel's book. It is deep and careful and compelling, and it welcomed me as a novice to philosophy, to dignity, to many of the doctrines discussed in the book by presenting these complex and nuanced ideas accessibly. And it provoked me to think about dignity and about what is and might be possible for courts to accomplish in a way that transcends even the extensive doctrinal areas that Rachel covers in depth. The book, I am sure, will influence my thinking for many years to come and the thinking of many, many others. The skill and richness of the work make clear that whatever Rachel chooses to do next with her scholarship will be important and impactful.
Great to be here. I graduated as an undergrad here not too long ago, 2010, so I'm always happy to come back to Charlottesville. Wahoo wah. No shots though. Nobody take a shot, please. Jim, you always expect to go last. I know I'll always be last, so this is not a surprise to me. I've long been a colleague and friend of Rachel from the civil procedure circles, and I'm really, really happy to be here to talk about her work. I'm going to start with some praise, and then I'll give 2 critiques or areas of concern, perhaps clarification too. The book is an impressive contribution to our understanding of dignity in the law. At first, you might think that recognizing dignity is a novel proposition. We need to let this percolate for a while. You might even think there's no apparent need to focus on this right now. But the book makes an arresting claim early on that I found really impactful. And that is that the status quo is not a neutral position. It is a choice that carries significant consequences as it is. Rather than simply ignoring dignity, the current legal framework, by treating dignitary interests as secondary, opts to address only material harms, while sidelining claims of disrespect, stigma, or domination. In other words, we're already making a choice about recognizing what types of harm are worthy of redress. We don't get to pick a neutral stance on this question. And this is incredibly important because that means there is no opting out of this debate. We either live in Rachel's world where dignitary considerations are central to different areas of law, or we reject them. There is no neutral position here. There's no ignoring it. There's no pretending that there is a third choice. Moreover, the way our courts understand and apply the concept of dignity affects some of the most contentious debates in our time. We've already heard about this. If you care about reproductive rights in the wake of the recent Dobbs decision, this is an extremely important book. If you care about privacy regulation and online harms, this is an important book. Given current news, if you care about separation of powers, this is an important book because of its discussion of standing. So one of the book's greatest strengths is that it has this ground-up approach to the concept of dignity, rather than merely examining how courts currently invoke the concept. The book delves deeply into its historical and philosophical underpinnings, and that reveals a rich moral justification behind this concept, demonstrating that legal recognition is rooted in long-standing moral foundations. And by establishing this foundation, the book then sets the stage for a more nuanced discussion of how dignity might be integrated into our legal doctrines. The book also makes a compelling normative case for why dignity deserves serious judicial consideration. It argues that addressing dignitary harms through expressive remedies can restore a party's rightful position. And finally, another of the book's most compelling contributions, and why I really enjoyed Rachel's original law review paper about this concept, is that litigants clearly want to press these arguments in front of the court. Litigants seek recognition of dignitary interests from the courts. Rachel is not putting this topic in front of us. She's saying litigants are already doing so. They're constantly filing these claims, seeking for respect, for acknowledgement of personal worth. And so this really reinforces the argument that dignitary concerns are genuine and it's not an abstract theoretical concept. So with that said, I want to move on to two critiques, as I mentioned. One is internal, and by that I mean internal to the legal system and the legal application of the book's proposal. And then I'll finish with an external critique, not about legality or the legal system, but rather about society and moral development. All right, so the internal critique. As I mentioned, one interesting thing is that the book is not claiming that recognition of dignity as a central topic would be an innovation. Quite the opposite, the book persuasively documents the scattered ways in which our courts already acknowledge dignity. The argument then is actually narrower. It is that making dignity central and explicitly recognizing it as either an injury or a source of damages or remedies would be better. That means that on the menu we have two choices. We either leave recognition of dignity scattered as it is and without a robust conception in many areas, or we make it central, explicit, and increase its importance. On the one hand, the book's argument for the central version of these choices is appealing because it promises clarity and consistency and actual recognition of many currently ignored harms. And yet, I have a major concern here, maybe a call for clarification. It seems like the current scattered approach, if we want to call it that, works well. It's unassuming. In fact, by allowing dignity to be implicitly recognized in some tort claims, in some constitutional doctrines, in criminal law, our legal system is making a choice that works in our favor if we care about these interests. Because they're handled in an understated way, they go unnoticed and uncontested in many ways. We don't have a large debate about whether we should recognize these interests at all in these different areas. I worry that making dignity an explicit centerpiece, the way the book argues for, risks and ultimately weakens, potentially, this concept. So overly centering dignity could politicize it. If dignity becomes a focal point of judicial relief, then every use of the term may be subject to intense political contestation. And that's particularly likely in an increasingly partisan judiciary. So I wonder if Rachel has really dealt with this problem. Shouldn't we expect the concept, if centered, if explicitly recognized, to become explicitly partisan? The way many other legal concepts have become. I don't know, say the consideration of legislative history. As soon as it became political, it became toxic for many formalists to refer to it. If we put it out there that this is a central concept that we should consider, then I worry that it's likely to actually weaken the consideration of dignitary interests across the board, not actually strengthen it. And the call for clarification is the argument that in these 10 different areas where we consider dignitary interest today, we should ramp up that consideration? Or is it that we should have one central concept that informs all these 10 different areas? I'm actually not sure and would love to hear more from Rachel about these two. Second, if we shift the focus of judicial remedies too strongly towards expressive dimensions of dignity, we risk altering litigant incentives. The book acknowledges this. Jim mentioned this as well, though I wonder whether the book is too quick to dismiss this problem. We might see litigants truly, increasingly, frame claims in purely dignitary terms, seeking symbolic vindication rather than addressing material harms as they currently do. Third, the book's call for a pronounced judicial role in recognizing dignity raises important questions, of course, about the proper scope of judicial authority. Many critics of the judicialization of politics argue that courts should remain cautious in areas that are analogous to considerations of dignity. Is this really the moment to call for judicializing more than we currently do? Especially, again, when we have an increasingly partisan judiciary. Maybe the argument would make sense if we believe that the current trends in the judiciary were not pushing towards more and more partisanship. But perhaps this isn't the right moment for this proposition. Now, I know the book addresses many of these arguments, and it does in a really robust manner. I'm going to let Rachel talk about that. The last critique is the external one, the societal critique. There's a broader social question here about whether judicially centralizing dignity is desirable. Rather than simply resolving disputes, an overt legal focus on dignity forces society to confront deep questions about our moral values. Centralizing dignity wouldn't just codify a legal norm, but actively shape public discourse on respect, self-worth, and social status. And I think this gets into a broader debate about the evolution of morality. So there are scholars in fields like psychology, political science, and sociology, including Bradley Campbell and Jason Manning, that have argued that morality has shifted over the past 100 years, that we've observed kind of moral revolutions. And some of this is related to what Jim mentioned about victimhood. Their argument is that originally we saw a progression from a culture of honor to one of dignity, actually, incidentally, that's the term they use, to one of what they call victim. And they don't say victimhood, but a victim culture. In an honor culture common in pre-modern or frontier societies, personal reputation is everything. Insults or slights are seen as direct challenges to your honor, your reputation for toughness or bravery. Conflict resolution is swift and often violent. Duels or physical confrontations are common. Under these conditions, people take offense very easily, and they grow quickly fearful and engage in higher rates of defensive or preemptive aggression. So that's an honor culture. They argue that we've seen an evolution from honor cultures to dignity cultures because of the development of strong legal and institutional frameworks along with economic development. In a dignity culture, according to these two sociologists, the emphasis shifts from the need to defend one's honor through violent retribution to an internalized sense of self-worth. Trivial insults can be brushed off. Sticks and stones may break my bones, but words shall never hurt me. People in this more modern form of society may resort to legal authority when disputes and wrongdoings are sufficiently severe, but otherwise they make efforts to privately resolve these disputes or to brush them off. All citizens are assumed to have a sense of dignity and self-restraint, and everyone is expected to give the benefit of the doubt when they hear something that they might find offensive. They argue, however, that we're seeing a shift in the last 10 years toward a victim culture. And in this emerging moral framework, sorry to be a boomer like Jim was, status and self-worth increasingly depend on publicly recognized victimization. That rather than relying on their own resilience, individuals are encouraged to seek institutional redress for even minor slights. Victim cultures share in common with honor cultures a sensitivity to slights or insults, but whereas in an honor culture you retaliate personally and often violently, in a victim culture you appeal to a powerful legal authority. And they use as examples Mao's China, Stalin's Russia. In contrast to honor cultures where we expect victims to be strong and stern, dignity cultures expect victims to be calm and charitable. Victim cultures emphasize how complainants are fragile, vulnerable, and weak. I wonder if this book, incidentally using a focus on dignitary interests, is actually doubling down on the victim culture part of this evolution. It's asking for an explicit, centralized judicial recognition of dignity, essentially asking our courts and other state institutions to step in and mediate moral conflicts that arise from perceived violations of dignity. In doing so, the approach, as I said, doubles down on this feature of victim culture, and it would seem to be a departure from the dignity culture ideal, actually. I wonder how we reconcile the use of dignity in both Rachel's work and the work of these sociologists, which has been very influential. So this might politicize a value that has historically been kept within the interpersonal realm and could, again, alter litigants' incentives. So I wonder what Rachel thinks about this potential critique. But on the whole, of course, this is a compelling book, well-argued, important, and it, of course, challenges us to take dignity seriously as a matter of legal and moral importance. And it raises critical questions about the role of the judiciary. And for that, I'm grateful to Rachel. Thank you.
Those were such wonderful comments and have given me a lot to think about. And so I think I have 10 minutes, and so I don't think I can really respond to every point that was raised, but I really look forward to continuing the conversation. I suppose in no particular, so on the concept of evidentiary proof, which came up in a couple of the presentations, I agree that this is a serious issue for dignitary harm. It's also an issue to a significant extent for emotional harm. There's been a lot of debate about the extent to which emotional harm should be compensable or recognized in court, given that it may be more difficult to prove. For emotional harm, sometimes you can get, a psychiatrist testifying, and I want to say that dignitary harm cannot be reduced just to emotional harm, so it might actually be even more difficult because dignitary harm ultimately is a matter of reading social meanings, and that will depend to some extent on community standards. So I think of, I used an example about a Texas case from the 60s where someone grabbed a plate out of the hands of a Black person who was waiting to eat at a restaurant, and said, no, you can't be here. And the person who grabbed the plate out of his hand was ultimately held liable for battery, which seems kind of odd because he didn't hit him, it was just grabbed the plate, but he made this offensive contact with him. And so there had to be this determination that was in fact an offensive contact. And I think even though it can be hard to prove that, and it does depend on a certain, understanding of the relevant decision makers as to what's reasonable and what's not, I don't think it's impossible to say that in fact there was dignitary harm. I thought it was very interesting, Jim Fander's point about the constitutionalization and federalization of tort law, especially when cast as this way for federal courts to reclaim control over the definition of rights of action that they had ceded in Erie. I agree with much of what he said about this phenomenon. I think that there is, though, this interesting return to tort law concepts in the law of constitutional standing doctrine. So in TransUnion and Spokio, to some extent, the Supreme Court is these Article III standing cases saying that we actually want to look for common law analogs to modern day harms. So even if Congress has defined a certain right of action and said these circle of plaintiffs are entitled to sue, we still want to ask, have they really been harmed? And in order to do that, we often look for the relationship to what the common law said. And I think this is part of this broader kind of traditionalist turn in the Supreme Court, which is actually what I'm writing about currently, and so just sort of is on my mind. But this idea that you want to find some tether to the past, even if you don't tie it to the specific moment of constitutional ratification. And so I think we're seeing there some movement in a way back towards tort law, only when we still ask this who decides question, who gets to decide about the content of whether this is cognizable injury, it's still ultimately, in the standing case, the federal courts. On the flip point that Rebecca Wexler raised, so I agree. I mean, I think that in particular in the last chapter on apologies, the dark side of dignity comes out more. In particular, the dark side of dignity in litigation, that it's possible for the procedures of litigation or I talk more about this particular remedy to actually inflict dignitary harm, even as it's an attempt to ameliorate it. I think this is also true of some of the procedure of litigation. So some scholars in civil procedure have written about, for example, the idea that a plaintiff needs to testify to having suffered certain forms of harm, or might have to reveal, personal information, and that itself can detract from that person's dignity, even if it's part of an attempt to claim dignity to some extent. So it is true that the processes of litigation and its results can result in these dignitary problems. And I suppose the question is, where do we go from there? It might just be a kind of trade-off that has to be made. I don't think the answer is necessarily to say we'll just give courts less power, because for many institutions, you might have the trade-off that if they try to promote some people's dignity, they might detract from the dignity of others. So as Diego Zambrano sort of alluded to, I think it's not really possible for us, or for courts in particular, to try to get out of the dignitary thicket. The question is, how are they going to treat those inquiries? And this brings me to Diego Zambrano's points, which I thought are very interesting about the kind of, do we want to try to have more explicit recognition of dignity, or is it better for it to continue to fly more under the radar? Perhaps that leads to less politicization. So I think that's a risk. It reminds me to some extent of arguments that Dan Kahan has made, for example, in a article called The Secret Ambition of Deterrence, where he talks about why people are for and against the death penalty. And they often say, I'm for and against it because of deterrence. But if you really ask them, they are not really concerned about deterrence. There are other values that are animating that position. And he nevertheless says, well, maybe we should still speak in the language of deterrence, even though what we really care about are issues about revenge or innocence or race or something like that, because those are really politically contentious topics, and it's better for us to stick to this more sort of neutral plane. And I can see the force of that argument. I mean, I do think that sometimes having dignitary interests fly under the radar can simply lead to their rejection. So attempts by Supreme Court justices today to say that so-called offended observer standing in Establishment Clause cases, like if someone goes past a religious symbol on government property and says, I'm offended by that, or let's say I've suffered dignitary harm, some justices would want to say, no, that's just offense. That's not real harm, and that's not a basis for standing. And in that case, there's an explicit effort to downgrade dignitary harm. So it's not just that it's implicit, but that its very kind of lack of explicit recognition could lead to a form of downgrading. And so I think that risk also has to be taken into account. On the question of whether I think there's one central concept of dignity, I do want to suggest a general account of dignity, even though it has these three different manifestations. So the status and domination and exposure. But in terms of how that manifests itself in particular legal forms, I think that would depend on the specific history and the evolution of a particular doctrine. So I'm not arguing on behalf of, just recognize this completely standalone, freestanding right or injury to dignity. It's more that interest is channeled through particular legal forms, for instance, in the domains of injury in fact or in various aspects of tort law. On the concept of resilience and victimization, I think this is a really important point, and is also in some ways related to the sort of negative flip side of dignity that Rebecca Wexler mentioned, that there are these costs, and I think the costs. One of the costs of having a culture where people are constantly claiming dignity may be that people are used to thinking about dignity as something that they will get from institutions rather than it's something that they will provide either by themselves, they're individuals, or as part of smaller communities. And I think that could have a societally detrimental effect. At the same time, I think that the language of dignity has played this incredibly powerful role, including in the international human rights regime, and is not something I think that we should be kind of quick to relinquish. I suppose the question then remains whether it's possible to, complain in a way without being fragile. So whether you can say, okay, I have dignity, that's part of why I think I've been treated wrongfully, but that doesn't mean that I'm going to spend my entire life in a sense of, railing against the ones who have wronged me constantly and, never making my own way. And I suppose that's just a challenge for all of us and for the institutions that we create. So I look forward to the rest of your questions.